Lufthansa is suing a passenger for having missed a flight. Okay, there's a little more to the story than that. They're suing a passenger for having missed a flight on purpose. Alright, there's a little more to the story than that. The passenger, instead of buying a direct flight from point A to point B, bought a layover from point A to point B, B to C, and instead of getting on the plane from point B to C, just stayed in the destination B as though it were his final destination. Apparently this practice, which is called skip lagging, is against Lufthansa's terms of use. Now, I got a copy of the proceedings, but unfortunately they're in German, so I don't know what it says, but I can only imagine what the damages Lufthansa is going to claim to have suffered are. Let's think about it. Delay in flights. Personnel to hunt down the missing passenger, because they do this on planes when they're missing a passenger. They take some time to find the passenger. Last call boarding passenger X, Y, and Z for flight ABC to city 123. So understandably, this causes delays which have a dollar value per second for airlines, and it requires the personnel to carry out additional tasks that they would not have to otherwise carry out if, for example, the passenger notified the plane company to the effect that they were going to miss their plane. Another header of damages that I imagine Lufthansa is going to claim in its proceeding is the difference in price ticket between the cheaper ticket that the passenger purchased and the direct flight that they ought to have purchased. Now, big parentheses. This lawsuit has already been dismissed by a German court, and Lufthansa is appealing the decision. Not only that, another airline company sued another passenger somewhere in the United States for the exact same reason. That lawsuit was dismissed, but on jurisdictional issues. And as far as Lufthansa is concerned, their lawsuit was initially dismissed, but on jurisdictional issues, not on issues of substance. Jurisdictional issues are sort of procedural, whereas substantive dismissal of suits are on the actual merits of the dispute. My prediction is this is going to get dismissed in appeal with costs against Lufthansa. And if they're not careful, they might get declared a quarrelsome or vexatious pleader, because this lawsuit is frivolous on its face for a number of reasons. This practice of skip lagging is a known problem. There's even a website called skiplagging.com which finds you cheaper tickets than direct flights by buying them as part of a multi-leg flight, where you just don't get on your connecting flights because you stay in what would otherwise have been your final destination. So it's a known problem. Airlines are aware of it. But instead of fixing the problem internally and fixing their pricing, they add in small print on the back of their tickets that it violates their terms of use if you indeed purchase a multi-leg trip but get off at one of the legs because it's cheaper than buying a direct flight. And can Lufthansa reasonably rely on the small print on the back of their tickets, their terms of use, to sue a customer for breaching their terms of use? These types of contracts where one strong party imposes all the terms and conditions are called contracts of adhesion, meaning that the person who buys the ticket in this particular case has no chance of negotiating any of the terms or conditions. He has no choice. Buy the ticket, agree to the terms, or don't agree to the terms, don't buy the ticket. Contracts of adhesions are one in which one party imposes all of the terms on the other without any room for free negotiation. And now Lufthansa are imposing terms and conditions which place the burden on the passenger to require them to buy the more expensive ticket if they find a cheaper alternative? Especially since this probably falls under consumer protection laws, which vary by jurisdiction, where you have the big merchant imposing onerous terms and conditions in a contract of adhesion on a consumer, a lowly consumer who just wants to buy the cheapest possible ticket to get from point A to point B. This is going to be interesting to follow, but I am predicting, and I'm going to predict it now, dismissal with costs, potentially legal fees, because they're forcing a passenger to lawyer up and defend not only in first instance before a first court, but in appeals. Dismissed. And if Lufthansa isn't careful about it, and it looks like they are trying to strong-arm weak consumers who have no choice but to agree to the terms and conditions of a contract of adhesion in the small print on the back of their tickets, they might get sanctioned for abusive conduct and potentially even be declared vexatious pleaders or quarrelsome pleaders. That is your dose of law for the day. Viva Frei. I am a Montreal litigator turned YouTuber. I make YouTube videos. Like, share, subscribe, hit the notification bell. I'm off to class right now. I'm at school becoming an accredited mediator. Peace. And you know what the other problem is? If Lufthansa had lawyers who knew business, they would know about the Streisand effect. By taking this lawsuit, Lufthansa is publicizing skip lagging? What was it called? Skip lagging? Lufthansa is publicizing skip lagging, and they're going to make it known to more people than would have otherwise known about it had they never taken the lawsuit in the first place. Skip lagging, children. If you need to get cheaper tickets, don't fly from point A to point B. Buy a ticket from point A to point B to point C, and don't get on from point B to point C. What did you learn, Lufthansa? What did you learn? Okay, that's good.